the Supreme Court had a similar case, the Tornillo decision, about the right of reply to newspapers, where the court distinguished it from red line, saying, well, there you're dealing with newspapers, you're dealing with not a scarce public resource, but a non-scarce, at least in those days, newsprint would seem to be non-scarce and endless, private resource, and therefore, no, a legislator in Florida got mad about something the Miami Herald wrote about him and went in and put in a bill saying if you get attacked in the newspaper, you've got a right to reply. And the court said you can reply somewhere else. But it's a very different thing when you're dealing with broadcast. And again, I don't know anybody who's arguing to bring it back. It's not an especially manageable rule. It's not an especially effective rule. But I think that it's based on a perfectly valid principle, and a unanimous Supreme Court agreed that the First Amendment is meant to promote discussion, and that's precisely what this rule did. It promoted the idea of dialogue.
Given the proliferation of radio resources today, is there any justification for treating broadcast media any differently than print media today, Jamie?
Well, that was my question to Tom. He wants to keep the FCC going. I'd be interested, in seeing.
That didn't sound like he was enthusiastic about it.
Well,
I'd like a right to a reply.
Yeah. No, my point about that is, I don't think there's no proposal in Congress to bring back the Fairness Doctrine. I don't know of any proposed rulemaking at the FCC to bring back the Fairness Doctrine. So again, I think that the whole debate is a little bit of a stalking horse for other things which are much more relevant to intellectual pluralism in the country today, like the concentration of media and the big mergers that come before the FCC. Then we come to a discussion of is the media better off? Do we get more pluralism and more dialogue and discussion with fewer corporate entities controlling the media, or more of them, more diverse outlets? And I think that's much more of the core issue that's confronting the FCC.
Well, we'll let the body before us inquire. Tom, you can briefly reply while people are lining up at the microphones.
Yeah, well, you asked me if their license is worth something. Well, of course it's worth something. This is entirely circular. It's worth a lot. I mean, the rents are high because the government has a public interest licensing scheme that explicitly excludes competitive entry. So that jacks up the price, but it also is a completely self-serving argument for advocates of government control to do what the Tudor kings did and say, that printing press, that was invented on a royal patent. That sounds good. We'll go with that argument. So now we're going to license the press, okay? That argument was wrong. In fact, historically, the argument that the government brought order out of chaos historically in the market through licensing is also wrong, as it turns out. But on that argument that the government is needed to bring order out of chaos, which is really the 1943.
It may well be, and I will not give any right to reply, that an FCC is needed to prevent the jamming of signals, no matter what else may be at hand. It's also the case that a lot of the spectrum that is being allocated these days is being allocated by auction and not by fiat, so that there is something being paid for that valuable license. And although there is talk of localism, since the Bechtel case, you no longer have the sort of arbitrary, and I can say my court decided the Bechtel case several years ago, you no longer have the kind of complete arbitrariness on that rule you once had. All that said, without giving a right of reply, unless he wants to pay me $7.50 for it, I'll let the audience begin. And let me say this, you're being recognized for the purpose of asking questions. We invited these people to make a speech. We're not going to subject them to listening to speeches. So somewhere in the near course of your beginning, let's have an end and have a question mark at it.
Was that directed at me, Judge Sentelle?
It was directed at the entire audience, Roger.
All right, listen, this will be very short. Jamie, you began your comments with a story about Sidney Morgenbesser. He also was at Columbia listening to Sir Alfred J. Ayer give a lecture on logic, in which Ayer said that a double negative always leads to a positive, but never has a double positive led to a negative, to which Sidney replied, yeah. And that was a mischievous answer, and I'm going to give you a mischievous question.
Okay.
You said that if it's a public entity, you would be in favor of the Fairness Doctrine. I assume that, for example, National Public Radio should be subject to the Fairness Doctrine.
Well, of course it should. I mean, if we got a Fairness Doctrine, why shouldn't it be?
Oh, I mean, it alone should be by virtue of being public. and a tax-supported entity?
Sure, well, of course it should.
Okay, you got your answer. Next question.
Yeah, so that's it.
Jay Schweitzer.
Yeah, but by the way, I mean, forgive me, but the idea that you print replies and allow equal time is not really that foreign and anathema concept to most respectable journalistic entities. Now, I would think that if we want to completely deregulate radio today and make everybody pay fair market value for the broadcast spectrum, then by all means, let's treat them like newspapers and everybody goes their own way and does their own thing. But the idea that somehow it was crazy to say that if we're going to give you this valuable piece of public property, a public interest attaches to it, that seems to me to be just a rip-off of the public.
Next.
Professor Raskin has said that he's a great champion of free speech, but this area is a little bit different because it's managing a public resource. And I'm curious how that framework carries over into another somewhat related and highly contested field, which would be current campaign finance laws, an example of which allows Congress to criminalize speech that criticizes incumbent members of Congress. I'm wondering if you think that in this context, presumably the government doesn't own elections. I mean, there's a public involvement in elections, but presumably we wouldn't say it's owned in the same way we might say the government, owns airwaves. Does the current, massive regulation of speech ostensibly for purposes of fairness and balance, is that justified in the campaign finance context if it would also be justified in the fairness context, or in the Fairness Doctrine context?
I mean, I suppose I don't really know what you're talking about unless you're referring to the ban that goes back to the 1907 Tillman Act on corporate contributions in election campaigns. Is that what you're talking about? Attempts to stifle corporate speech in elections? Because I'd love to address that, if that's what you mean.
There are several examples. I mean,
Yeah.
I think one of the most prominent of which would be current laws banning, certain kinds of issue ads, which, were recently.
But corporation, okay, so we're talking about the same thing. You're talking about McCain-Feingold, and okay.
Sure.
Well,
McCain-Feingold, yeah.
Yeah. And obviously the Supreme Court has reached out in an extraordinary outburst of judicial activism to consider whether or not to topple a century of campaign finance law, which says that corporations are simply not citizens under the Constitution of the United States. It's we the people, not we the corporations. The corporation, it's always been understood, this goes back to Chief Justice John Marshall. Chief Justice Rehnquist repeatedly spoke of this. A corporation is a creature of the state. It's endowed with all kinds of benefits and advantages by the state, including limited liability for the shareholders, perpetual life, bankruptcy protection, and so on. And it must accept the restrictions put on it by the state. Now, of course, it can't be used, those regulations can't be used as a guise to violate the rights of citizens, but anybody who's a corporate shareholder or executive has a perfect right to engage in free speech, to give campaign contributions, to engage in spending, and so on. The proposition before the court today, which I think you would probably find sympathetic to where you're going, is that corporations should have the rights of human being citizens in the United States and should be able to spend to the heavens in federal election campaigns. In 2008, ExxonMobil had profits of $85 billion. If they took a modest 10% of that money, $8.5 billion, and spent it on federal campaigns, they would have spent more than the Obama campaign, the McCain campaign, and every House and Senate campaign put together. That's one corporation. You multiply that times the Fortune 500, we're not living in anything resembling a democracy. It's a corporate state at that point. So I would say what has defended freedom of speech of human beings and citizens is precisely the wall of separation which we've tried to erect between private corporate power, which is lawfully and rightfully assembled for economic purposes, but not for political purposes.
Does anyone else on the panel want to address that subject before we move to the next question?
I just want to say there seems to be this constant conflagration that the public owning the airwaves equals completely the government owning the airwaves. And I would argue that that's not necessarily the case. I have a very free market approach to radio and how it should be regulated. And if the public is interested in what is on the airwaves, their use of their resource is being served. And there's no need for any sort of government intervention or inserting itself in the process.
So are you opposed to the indecency rules too?
I think
If the public wants to see
criticizing your politician is a protected First Amendment right. Getting naked next to a pole for money isn't.
even if the public wants it. I mean, the test you established was, does the public want to see it?
I'm not I know I'm not a huge fan of the indecency rules, but I do think there's a fundamental free speech, First Amendment difference between political speech and indecent speech.